right. Well, hello, everybody. I know there's a lot of interest in today's session. So if you've shown up today for a buyer compensation update with Ed Zorn, you're showing up in the right place. I see we've got people joining the call right now. I do see some familiar names coming in, and it's great to have our group coming back together again. Those of you that are just joining us, if this is the first time you've been with us, first of all, welcome to this call. We've been running a series of calls aimed at leadership, management, team leaders about industry-related issues. So it's broad. We cover a broad set of topics. We have covered many different things. Today, we're going to be talking about the buyer compensation lawsuits and issues in the industry. And so if you're showing up here for that, you're in the right place. I think it looks like we've got a good number of you already logged in, and we are just about on time. So I'm going to go ahead and get us kicked off. So my name is Jack Miller. I'm the president and CEO of T360. T360 is a management consulting and research firm in residential real estate. We work principally with brokers, franchisors, real estate associations, MLSs, technology companies that service the industry, and work broadly across the industry. We work with about 300 to 400 clients a year on a variety of management-related issues in residential real estate. In addition, we publish 2 books a year, the Real Estate Almanac, which is an in-depth analysis of all of the players in real estate, and the Swanepoel Trends Report, which is published every December, which is an analysis of all the trends impacting the real estate industry. I am delighted to welcome today Ed Zorn, who is General Counsel for CRMLS. And Ed, you've been a tremendous resource on a variety of issues, both for our Trends Report and to the industry broadly. I know you're a highly requested speaker on many topics, but especially in the last couple of years, these buyer brokerage compensation related cases. And we're just delighted to have you today to speak to our audience. So I think I've given you a fairly fulsome introduction, but anything else we should know about your background before we jump into some questions and get some of your perspective on what's happening in buyer brokerage?
Right. Well, first off, I'd like to say thanks for the opportunity to jump in, Jack. We appreciate the work that T360 has done, for this space and some of the leadership that the organization has provided. The conferences or some great events that we've gotten a lot of great information out to help the California Regional MLS. A little bit about my background. Obviously, I've been an attorney for over 30 years, always in the area of real estate, but I've also been a broker for 20. And in that capacity, I operated a small residential firm. I've been part of a giant franchise organization. I also did a lot of commercial work. I got a CCIM designation back in 2006. So in addition to some of the legal things here, this time like this just happened to suit some of my past skills, because I have actually been in people's living rooms. I've shown properties to buyers. I've entered into buyer rep agreements, boot on the street type of action. So I try to bring some of that perspective in addition to the legal analysis of what's happening. So I think it's important maybe for some of the listeners to know that I have that kind of a background.
Super valuable and very similar. The T360 team is mostly composed of people that have been practitioners, run brokerages, sold real estate, run real estate associations, run franchises. So really appreciate that background. Because of our topic today, I do want to share those of you that have been on any of our conferences have touched this topic, know that we are working with an antitrust issue with some of these compensation lawsuits. And so I will read quickly our antitrust disclaimer. Real estate agents and brokers should not discuss fees or commissions with other brokers as it is a violation of the Sherman Antitrust Act, which prohibits price fixing, group boycotting, and other antitrust violations. We will be taking questions, but what I would ask is in your questions, and if you do participate in the Q&A in the chat, please do not mention any specific fees or anything that would come afoul of the antitrust notice that I put in front of you. I'll also separately say that T360 we are not an attorney firm, so anything that we talk about here today is really purely based on our study of the space and should not constitute legal advice. You should seek your own legal counsel. And I think Ed, while he's also an attorney for a significant company in the industry, he is not your attorney.
Right. Correct.
Yeah, so Ed's not going to be trying to answer specific legal questions for you, but we are going to produce some assessments of kind of what's going on with buyer brokerage. But if you have specific questions, definitely consult your local legal counsel and seek advice from them, as they'll be able to handle your situation appropriately. So with that, Ed, why don't we jump into kind of getting everybody caught up on kind of where are we with all of the lawsuits currently? Give us your kind of 10,000-foot view. What's going on right now?
Sure. The biggest one that people are familiar with, obviously, is the Sitzer-Burnett case. This is the case that resulted in the verdict from a jury back on Halloween of last year. So let's start with a little update on that case. So we did get a verdict, and I'm assuming your listeners are well versed. They understand what the claims are from the sellers overpaying commissions because of the concept of sharing commissions inside an MLS and all of that. So I'm not going to go through the background of what got us here. But procedurally, the jury rendered a verdict at the end of October, and we are now in this period of what we call post-trial motions. This is very normal, and this is where the parties get to bring motions in front of the judge about, one, how he handled the case, and NAR and the corporate defendants have brought a couple of motions like that, asking for basically a new trial, saying that the judge made some evidentiary mistakes. Normally done, almost never wins as far as the defendants or the losers are concerned. There's a second group of motions, though, that I think is a little more relevant, and that is motions notwithstanding the verdict. And these are some legal arguments that are made that are very technical. And I think NAR and the corporate defendants have argued a really good point from a legal standard here on standing. And we have a principle in antitrust law that says if someone's going to be a plaintiff in a case, they have to be the direct purchaser of the services from one of the defendants. Well, in this case, obviously no seller bought any services from NAR, right?
Right.
And arguably nobody bought any services from any of these large franchisor entities, right? You buy services from an individual listing broker who may be a member of one of these companies, right? Or a franchisee of the company. Well, they're separate and distinct companies. So there's a line of cases called Illinois Brick that talk about this principle. And NAR has argued it in this format the first time here in this motion that, hey, look, none of the defendants here ever provided any direct services to any plaintiff. And as a result, the case should be kicked out. I think it's actually a pretty compelling argument. But the thing to keep in mind is it only works in this one single case, because in all of the 20 copycat cases, and I'll kind of transition to that next, right? That there's 22, 23 plus copycat cases going on right now. In every one of those copycat cases, those plaintiffs did, in fact, bring actions against listing brokers that signed actual contracts with the plaintiffs. So while this argument might help NAR right now in this immediate moment, it does not at all solve the overarching problem that these other copycat cases are involved in. So procedurally, what's going to happen is these motions are being heard through the middle of April. So Judge Boo, who's the judge in this case, is very quick. He's very efficient as a judge. And so, we could be having some kind of actual judgment sometime, last half of April would be my best estimate. And then procedurally, what would happen after that? Number one, if he finds in favor of the defendants on these technical legal arguments, then the judgment goes in their favor, and technically the case would be over, right? Or if he doesn't grant these motions from the defendants, then he issues his judgment, right? We'll lock in a price, right? Which would probably be triple the 1.8 billion.
Yeah, that's the 5.6 billion everybody has been talking about.
Correct, right. He's allowed to treble the damages, right? And so if he does that, then we now have a judgment in place. And now that starts a 30-day clock for the purposes of filing an appeal, which we know will happen. And that's also the period of time where we could expect some kind of bond hearing, where the court can issue a stay on what they call the execution of the judgment, meaning that the plaintiffs won't be allowed to go collect on it as long as NAR posts a bond. The bond is not, and I want to be clear about this because I've seen some people write about this that's a little bit not accurate, and that is the bond is not the full amount of the judgment, right?
Ah,
The bond can be less than that. The judge will be allowed to kind of balance the interests of the
mm,
parties to
mm.
try to set a bond amount that protects the plaintiffs as much as possible, but that doesn't necessarily cause a bankruptcy or a destruction of the defendants, right? That wouldn't,
Yeah.
then once
Yeah,
they
that
come
would
to a
that would
hearing,
be unfair to the judicial process to
right?
say you have to post a bond that's so big that
Right.
you're going to go bankrupt from the interest anyway, and it kind of
Exactly.
defeats the purpose. Yeah, yeah.
Exactly. Right. So there's this,
I have heard that. I have heard some people saying, "Oh, well, just getting the bond is going to mean that's the
yeah.
apocalypse," and it's like, nah, I don't think so.
Yeah,
So,
that's not exactly how that works. Exactly. You're exactly right. There's more fairness involved in the process. The other thing that could happen right after the judgment is it opens up a window for the plaintiffs, once they succeed and get a judgment, to ask the court to issue an injunction, right?
mm,
So that's still on the table, and that would be impacting the rule, what kind of rule, and what's the scope of a potential change in rules that the judge can implement and order NAR to implement, right? And then there's some questions about what will be the breadth of that rule. Do we really want judges writing rules, right? So that kind of comes into play, and that, so that is something else that can happen kind
mm.
of post judgment, and the timing and impact on our industry of that is something to keep an eye on.
And that's because the court is federal that they could do that, right? Is it the injunctive piece of that where they could do something that impacts everybody?
Yeah, so keep in mind, one of the things the plaintiffs asked for here is an injunction against NAR. So what would that injunction look like? If the court says, "Hey, NAR, I'm telling you, you have to create a mandatory rule for NAR that says no offers of compensation in the MLS are permitted," then that's a rule that NAR has to apply by. Now it goes to NAR as to whether that breadth of that rule is
Ah,
going to be national, or are we going to limit it to only Missouri,
or only
right?
Missouri.
So
Got
there's
it.
a lot of unknowns on the implementation and the breadth of that,
Yeah.
and how NAR would decide to
To go
to
about that rule
deal with that
change.
kind of an order. So um,
Mm,
that does definitely present challenges no matter what comes out of the court. There's going to be challenges for the industry, in dealing with it, right?
yeah.
But that's kind of the big Sitzer Burnett case kind of status.
Yeah.
I mentioned in that copycats, right? And I think that's really the driving force for what you're seeing also procedurally coming up here just in a couple of weeks. There is a panel of 7 judges. They come from all of the different federal districts across the country. And
Mm,
what this panel of judges does is they meet once a quarter. And again, the next meeting is coming up here in a couple of weeks. And there has been motions brought by the plaintiffs in some of these cases. And NAR and a lot of the defendants have responded
mm,
about consolidating and pulling these cases all in front of a single judge.
mm.
And what the panel of judges looks at is, one, is that beneficial for judicial economy and fairness? If these cases are truly all exactly the same, on the
Right.
same kind of facts, involving some of the same people, right? Should we let one court handle the procedures, the discovery, the case management? Um, the real point here is to really try to drive settlement, right? So by getting all of the
Right.
plaintiffs and all the people in
Yep.
one kind of
Yep.
group, that helps foster communication. So that's another element. And the courts really look at, what judges have experience in this field, who's maybe handled a case like this before. That's going to be a wink, wink
Interesting.
towards Judge Boo in Missouri.
Yeah.
And who has been successful at maybe getting these things settled. Again, we have a lot of settlements that have happened in this case with some of the corporate
Mm,
defendants. And so there's been a history of success in getting parties to agree to an overarching settlement, which maybe leans towards an appointment to Judge Boo. NAR is asking for Judge Woods in the Northern District of Illinois, who has the Morrell case, which is the
mm,
case that started it all. The problem is that case is 5 years old, Jack. It
mm.
still doesn't even have a trial date, right? So she's
Yeah.
not pushed the case along as much as Judge Boo. And that's one of the considerations I think the panel will take into account when deciding where should this, big
Yeah.
chunk of cases go.
Very interesting. And then tell us about the large companies that have settled, because obviously, notably, Remax and Anywhere kind of first out of the gate, and then Keller Williams settled about 6 weeks ago. Came to terms. Are they out of the woods, or what's the status with those organizations?
Yeah, so the settlements were very large in the standpoint of it covered the whole country, right? So we all know these are class action cases, and so I've all read articles about the certifications that have happened in first the Sitzer Burnett case, then the Morrell case. What these cases settled was Sitzer Burnett, Morrell, also the No Select case, which we'll talk a little bit about in Boston. And they created an additional class of members, which is every seller in the country
Oh,
who
wow.
listed a property in the MLS
Mm,
4 years before the date approved on the settlement by the judge, right? And those motions are now pending in front of the courts. And I believe that is it's either May 5th or May 9th is the date. Beginning of May is the date for the courts to approve that settlement. And it is a national class. So what it covers then are the franchisees, right? The brokers who are parts of these
mhm.
franchise entities. But remember, it's only for sellers who sold
Sellers.
their home.
Mm,
That leads us in the fact that there are a couple of buyer side cases where the buyers are arguing they've been damaged because it's really the buyer that pays the fee, not the seller, because
mm,
the fees in the purchase price of the home.
mm.
So these settlements don't impact those cases, right? Those entities who've been sued or brokers who've been sued from these franchises. If they're involved in these buy side cases, they're still involved in those buy side cases. I think the other issue that's kind of still floating out there too is the rule hasn't changed yet.
Yeah.
So
Yeah.
the coverage goes backwards. But if you're part of a
Not forward.
conspiracy, it doesn't go
Yeah.
forward. So what
Yeah.
happens on May 10th, right?
Yeah. Yeah.
And so there's some aspects there where while that's very beneficial for those entities in kind of getting out and moving the ball forward, are they all out of the woods yet with no liability at all ever? I wouldn't
Yeah.
say that.
Debatable. Yeah, debatable, because we're not talking about go forward and the buy side of the cases, and even the current, settlements have to be approved by the
They
court.
still do have
And
to be approved.
yeah,
Correct.
yeah. So we're still in process. I think the way that it reads from the headlines and even from some of the on stage that I've seen is those organizations are saying, "Woo, we're done," But
Yeah.
that's actually a little bit of maybe a little spin on what's happening there.
Yeah, there's
So
still a little bit more work and a little bit of risk still involved. I mean, certainly they put a good foot forward, right? In protecting their franchisees and their brokers. And
yeah,
I want to commend them because that's hard work to get a large settlement done under these things. But until the rule changes,
right.
they still have some issues.
Yeah, we've resolved the past. We still need to talk about the future.
Right.
So, well, that's a good segue into talking about kind of what's going to happen in the next 60 to 90 days. Like, you have the multi-district, the judges getting together to decide where, kind of where are we going to consolidate, things like that. What else is going to happen in the next 90 days that's important?
I think really that's really one of the most important things, right? Is where is this going to end up as a large, the large body of cases? I think, and I'm hoping that there are still continuing settlement conversations. I'm very thinking that's occurring when you look at the timing of the Keller Williams resolution that you had just mentioned, right? Realize that came many, many months after the verdict, which tells me the plaintiffs and the parties are still in some room
Still
somewhere
talking.
with some
Yeah,
mediator
yeah,
talking
yeah,
about how to do this. The other thing that's beneficial about that is you now have a bucket set up, right? You have a system set up of how to handle claims from sellers, process those claims, a place to stick money from people who settle. So can that fact be leveraged to deal with NAR, the rule, right? So I'm hoping that there's some additional conversations going on. I think another driving force for that, Jack, will be how does Judge Boo rule, right,
yeah,
on these post-trial
yep,
motions that are still pending, right?
Yeah.
And then what happens with whether the plaintiff files for an injunction or not if they win? And
Yeah.
what does that rule look like? And does the DOJ step into that case
Yeah.
and make some comments about what a rule
Yeah.
might be, right? So these are, I think, the things that we're really, I think you're going to see a lot of focus on what comes next for a rule, whether that is a focus in settlement talks or a focus in post-trial motions, right? I think as an industry, that's really the thing that has to be kind of picked through and decided next. So
I think the other question a lot of people have had is around, if let's say NAR is going to settle it, what does that process look like, and how do we get there? Versus if they're going to fight it, like what do those two future scenarios look like? Because they're very different and they have different impacts to our our brokerages, our franchisors. What are those? Talk to us about the appeal process, the continue to fight versus the settling process.
So I spent 15 years as a litigator, right? So I
Yeah.
can tell you with absolute certainty, the fight never stops and should not stop. So NAR should keep fighting. NAR should keep asserting their rights. NAR should file for appeals and get a low bond, push for a good bond. That all should still happen. But at the exact same time, they should still always be open to a resolution, a solution that resolves it for the industry moving forward. So those two aspects are not at all mutually
They're
exclusive.
parallel. They're
Should
not one or
absolutely be
the other.
parallel. Correct, right. And one helps the other, right? The stronger your fight, the more likely perhaps a settlement can happen, right? As long as that settlement is on the terms and has, especially for the industry, aspects of a rule change that is positive for consumers and still supportive of the concept of the MLS as a broker cooperative and supporting what that aspect is, right? So there's a lot of nuance, a lot of issues there, but they should both be happening at the exact same time with a high level of energy on both.
Yeah, that makes sense. And then I think the concern we have out of the brokerage community is that the longer this goes on, and I know we have some people on this Zoom who have been named. So there's some brokerages that are here because I've known some of the people that we
invited. As is the company that I've been.
Yeah, and exactly. And so there are people, and we also know from talking to them that you get served, you get a subpoena, you get served, you're like, oh, now I'm involved in this thing, and you call up your attorney and you say, look, we got to get involved in this thing, and then people are saying like, oh, I'm budgeting $250,000 for just responding to this. So I think they're looking at it and saying that. What is your sense of how long this process is going to go on, and what does that look like, and what should people be considerate of in terms of the expense if we continue to have to respond to these cases? What is that?
Yeah, and that's always the challenge, right? So lots of cases settle, even though the defendants think and maybe have great arguments that they did nothing wrong and that they owe nothing, right? That is just because of what you just expressed, right? There are business reasons to settle a case you might win, right?
Yeah.
And I think that has to be taken into account by the leadership of NAR, by those who are in rooms where settlement discussions are happening. That clearly was taken into account from the leadership teams of Keller Williams and Anywhere and Remax, right? They went through that process of weighing those business needs and certainty of the future against the ability to continue to fight and the success of that. I think as long as the people making those decisions are looking and always open to an acceptable solution that takes care of the consumer in a way that still supports this principle of broker cooperation through an MLS, which, by the way, is the most important and greatest gift that the brokerage community has ever given to the real estate consumer. Realize no other process in the world has what we have. And it's a gift from you, the brokers, to the consumer is the huge beneficiary. Art Carter, our CEO, talks about that all the time, that how important that element is. So it's that balancing act of business needs. I think that there's a path to getting this settled, because the hard part is on an appeal. You're talking 3-4 years, right? What if you win the appeal? Great. Your reward is
Yeah.
just a new trial.
You new trial,
Right?
you get to continue to
Fantastic.
pay for lawyers, you get to,
Right.
you just signed up to do that whole thing all over again.
Correct. Right. So there's definitely a very practical impact. And that's what I'm saying. If the plaintiffs can be reasonable and the consumer advocates and the DOJ to understand the importance of what we do in the broker cooperative, which is the MLS, and the importance of good quality rules to make a good marketplace for the consumer, as long as they're realistic and don't live in fantasy land, right?
Yeah.
Then I think there's this place
Yeah.
in the middle that we can find.
Yeah, that's good. Well, that's a great segue. I will put a note on. I think everybody going through the market they had in 2023 and what appears to be, we're not going to flip a switch and be back to 6 million transactions this year. We're in a recovery cycle right now. I think most brokers feel that, and that while there's some green shoots, we're a long way off. So I think many of them feel the pressure of of one of the most challenging housing markets really since the 90s. So
yeah, especially with the interest rate and the impact that had on buyers. I still do in my spare time as a hobby represent buyers, where I live locally, and so I understand that impact. I watched it happen.
Yeah.
People who are interested in buying homes and just getting priced out because of both a price appreciation and the interest rate. So that's a very real crush that we had to deal with.
Well, I think one of the key elements, and I know you and I have talked about it. I know you've talked about it with James Dwiggins and some other industry leaders and some other MLS attorneys, are the rules changes themselves. Because I think there's kind of, if the industry is going to end up on some sort of settlement, it's going to have components. There's the rule change components, and then there's the financial components. Why don't we talk about, especially in light of the DOJ commenting on the no select case, as you mentioned, why don't we talk about what is it that they want? What do we think those rule changes look like? How's that, and how does that impact brokerages?
Sure. Let's talk a little bit about the no select versus MLS pin case. This is a lawsuit out in Boston. It's much newer than the Morrell and Sitzer Burnett case. It's interesting in that it does not involve the National Association of Realtors. It is a broker-owned MLS, but shock of all shocks, they had the same exact rule, right? With a offer of compensation field in it. And that's really the rule that's being attacked. And so MLS Pin settled the case with the plaintiffs. They agreed to pay some money, but more importantly, they agreed to change the rule. And the rule that they agreed to change really was to mimic what was done in the Seattle area with Northwest MLS. And that was everybody's current MLS rules talk about the offer of compensation goes from the listing broker to the buyer's agent, right? The buyer's broker. And the idea is I negotiate with you, Jack, as a seller, as a listing agent. I come in and we set a certain price for my fee, and I agree to share my fee with someone representing the buyer. And that fee is set by me, the listing agent, and you, the seller. And we're going to decide what the buyer's agent gets paid, right? That's the concept of what the sharing of commission is happening. And so in the rule change that was proposed by MLS PIN, what they said is instead of the offer of compensation coming from the listing broker, it's going to come directly from the seller. And I think the most meaningful change of that rule was it made it so it was not a automatic acceptance, right? The buyer had to do something in their contract to make this offer or accept this offer from the seller. And so the forms had to change to accommodate this between the contract between the buyer and the seller. And so that was, I think, the most significant potential change of this rule. And what the Department of Justice came in is they said that's not good enough, right? Just switching it from listing broker to seller. Their argument is the seller pays it anyway. This is all just pretend, fanciful nomenclature, right? It's still coming out of the seller's proceeds. So it's a change with no change. There's no substance to it. So what the DOJ then is they filed an objection to that settlement proposal. And in that objection, they basically, articulated this is not good enough, not enough change. And they did give us a little hint of what is okay. And the DOJ said they are very, very comfortable with sellers actually paying for the buyer's agent fee. They have no problem with that. They just want a couple things. They want the buyer and the buyer's agent to decide what that fee is, not the listing agent and the seller deciding what the buyer's agent fee is. That's one.
That's one.
And
Yeah.
yeah, and they want that acceptance, that discussion of what that fee, how much of that fee that the buyers agreed to pay the buyer's agent is going to be paid by the seller. They want that discussion and negotiation to happen in the contract to buy the property between the buyer and the seller. What they're in essence saying they're good with and arguing for is the exact way that we've done commercial real estate forever here. I got my CCIM, back in 2006. There is no MLS in the commercial world, right? There is no unilateral offer of compensation to do a unilateral contract for commissions like in residential. But guess what? I've represented hundreds of buyers in commercial transactions. I've always got paid, and I almost always got paid by the seller, right? And we just make it part of the contract, right? So this is not breaking new ground. This is not like, oh my God, how's this going to work? This is kind of the norm in other locations and in other property types. So
yeah. So that kind of leads us to, there's a set of rule changes that I think you and some other MLS attorneys have been discussing to put forth to say, look, this is a package of changes and some business practice changes that we think together could be a part of the solution, part of a settlement, whether NAR does it, whether separately a group of brokers gets together and decides to do it. But talk to us about what is the structure of the rule change that you would propose or that has been discussed as solving that.
Yeah, I think it's exactly in the context of a settlement, right? The rule changes that we're going to talk about right now are when I say rule changes, what I mean are changes to the NAR MLS handbook, right? And some of the mandatory policies from NAR. I think NAR is still an important entity. We still need some level of management of universality across the country of what these rules are. Otherwise, you have havoc in a marketplace. If you have 5 different MLSs with 5 different ways of handling this, you end up with 5 different forms. 5 different ways of learning how to present it to sell it, right? Trust me, we need some level of uniform nature of how this functions. So the context of this would be, again, an anticipated settlement that resolves this, which, by the way, means we have to take a step or two towards the plaintiffs, towards the DOJ, towards consumer advocates of what their criticisms are. Otherwise, you're not going to settle, right? And that's the context. So it's really 3 things, and it's 3 things as you expressed it as a package. The number one thing that the DOJ really doesn't like is steering. This idea that the buyer's agent has his hands on the bus, and that's who's deciding which property gets bought because of the pricing, right? That's the concern. So attacking the concept of steering is important, but there's 3 aspects that kind of go together. And if you take any one aspect out and analyze it by itself, it doesn't get the job done. You kind of need all of it together. And I think the first aspect, or the first thing that has been kind of discussed or evaluated is something that's been talked about for a long time, and that's mandatory buyer representation agreements, specifically that they be signed before a showing, right? And this, I think, really attacks the steering issue straight up, right? So if I sign a buyer representation agreement with you, Jack, for you and your family to go look for a home, and I have to do that before we ever open a door, before we ever show a property, I have to sell you my value proposition. We have to talk about all the things I'm going to do for you. My list on my buyer rep agreement has 16 items that I do for you, right? Spelled out in very simple language. And then we're going to agree on the fee that I'm going to charge you, and you're going to pay me for that service. So now, whether you are interested in a home that offers a low commission or offers a high commission, what does it matter to me? I'm getting the commission and the fee that you and I talked about. Right? That means I can also take you to a for sale by owner. I can take you to a builder, right? The whole world opens up when the fee is set between you and I, at the very beginning of the relationship, right? So that's I think the most important element that really gets rid of 85% of the steering opportunity scenario.
Mm-hmm.
I think the second rule that needs to be addressed is the one that the DOJ and is kind of the heart of what these complaints are, and that is an elimination of the formal contractual offer inside of the multiple listing service, right?
Mm-hmm.
So realize right now, the way this works is it's a blanket offer. It's unilateral. That means that to accept the offer as a buyer's agent, all I have to do is bring the buyer. I don't ever have to talk to you about the rate. I never have to negotiate it. None of that happens. And it's this weird kind of unilateral contract that drives the concerns from the consumer advocates and the DOJ. So let's just get rid of it, right? We don't have it in commercial. Deals get done with buyer reps all the time. There's no unilateral offer of compensation, right? So we know in the United States, deals get done without it. It's not a problem. So let's get rid of it. The concern a lot of us in the MLS industry have, though, is for consumer protection in throwing, as they call, the baby out with the bathwater.
Right.
There are some very positive aspects of transparency and knowledge about how you put a transaction together that comes from the buyers and the buyer's agent knowing that the seller is willing to take some of his proceeds to encourage a buyer to come to his property, right? We see it in concessions, especially you mentioned 2023, right? How many of your offices out there, did those of you on this call have where you were doing 2-1 buy downs, on loans, right? How many of you were as it saw in your listing agreements, right, where the seller said, hey, I'll pay for the title fees or the escrow fees or lawyer fees of the buyer to make it easier for the buyer to come to my property versus someone else's property, right? That aspect of disclosure, that aspect of transparency, and a seller deciding to create an incentive should not be lost in any type of new rule. And I think it's important for that transparency to remain there, so that maybe a consumer who doesn't have an agent is aware that
there are seller concessions available.
Absolutely. Yeah. So that's the concept. We don't want to throw the baby out with the bathwater. There's some really good consumer friendly positive aspects of this display of compensation.
Because you want to let your VA buyer, you want to let your first-time home buyer, you want to let your, those folks know, hey, there are concessions available to make this a more affordable transaction for you. So that's valuable.
Absolutely. And that's under protected speech, right? As a seller, I have the right to make that as part of my advertising pitch as I'm in competition against other maybe entry-level homes. Right. That I want someone to come to my home instead. And we see builders do this all the time, right? How many builder incentives do you see where when things get a little slow, all of a sudden the builder is cutting out loan points or throwing in some upgrade on flooring or something, right? This is just a normal, how a market works.
Yeah, totally.
And so I think we have to be careful that we don't get so extreme with a rule change that we throw out the benefits of that communication and that ability to protect the consumer who wants to go to properties because they need help getting in, right? And that should still be able to be communicated. So that's that second rule. And then I think you have to finish the changes in the rules by sandwiching I call it the concession and list price field, right? With dealing with the end of the relationship. And what I mean by that is some kind of rule. I'd envision this as a change to the code of ethics and the addition of a standard of practice 7.1 that would say something along the effects of, hey, a buyer's agent cannot receive more money in broker fees than what was agreed to between that agent and their client in a written agreement. And that you're sandwiching this concession and list price now between a buyer rep agreement at the beginning of the relationship against this rule at the end of the relationship that says, hey, look, Jack, you and I agree that I'm going to do all these 16 things for you for X. And we start looking at properties and I introduce you to a property where the concession and list price is X plus 1%. right? So there's 1% more in the deal than what you and I have agreed to in writing that I'm comfortable getting for my fee. Well, as a good human being, there's no scenario in which I'm going to work for more than X, right? Because that's the contract I signed.
That's what we agreed to on the front
to.
end. I'm going to supply the services. I'm going to get paid for the services.
Right. Yeah. There's absolutely no scenario where a broker should ever get more money than they agreed to be paid from their own client. I'm assuming you wouldn't pay your lawyer 30% more than what your contract with your lawyer says. I'm guessing most people on the call would object to that.
Yes.
And so we shouldn't allow our industry to have language like that in agreements, right? That we would never agree to as a consumer. And so the idea here is at the end of the relationship, if we had some kind of code of ethics and it made its way into agreements, right, that assures that we won't be keeping any spread. Now, when you and I have this conversation, I go, hey, Jack, we're going to make this offer on a property. We got this extra percent. How do you want to spend it? We can offer 1% less. That way you and your family can put it in your pocket. Hey, you need a loan? Let's apply it to some of your loan costs or fees. Hey, I think there might be 2 or 3 other offers coming in on this property, Jack. Why don't we leave it in the deal for the seller? We'll give him his advertised list price, knowing that he was willing to give up this extra percent, and we'll let him keep that money.
Yeah.
Right?
And
so
make our offer stronger in a multiple offer situation because
exactly, right? So under any scenario, the consumer keeps this potential advertised additional money. Right. So I think it's the overall package of the 3 rules together that works well, right? The beginning of the relationship, certainty of negotiating a price, no offer of compensation, but we retain the transparency benefits of a communication of a concession list price. And then we finish the relationship with a rule that says, I'm not going to keep more money than what you and I agreed to. That's not a hard one to sell.
And there are many agreements that have that language in it already that that we've observed in the kind of the buyer brokerage realm. Not enough of them, but there are agreements that have that.
Yeah, and the advantage of that becoming a code of ethics standard is all of the realtor association formulated forms will immediately be changed to accommodate the code of ethics standard.
Yeah.
Right. So it's like a fast track to really help improve the buyer rep forms by embracing that rule.
Yeah. So we do have a lot of questions that have come in. And we'll try to hit a few of those at the end. But I did want to cover off when we're talking about what does a potential settlement look like. So we covered the rule change portion of it. Again, the proposal I've seen circulated, and I believe has had some comment on it already, has a financial aspect to it. How do we I feel like most of the brokers are on this call do not have 30, 40, $50 million
just laying around doing nothing.
Just laying around, of which they can write a check over to if they said, I want to settle this case. They don't have that. So what's the proposed structure for the financial part of any settlement or of a potential settlement?
Yeah, this could take a lot of different forms, and it depends on who settles and who's driving the conversation. Some things we know from the settlements that have already occurred, Jack, is that I kind of did an analysis of how much each of these entities paid, right? You have the 3 that are already settled. And I actually took a deep look at the transaction they've had in the last 4 years. And interestingly enough, they're all within a couple of bucks of $30 a transaction side.
Interesting.
Right. So it's almost like $30 a transaction side is kind of where the current
going. That's basically the going rate for the big guys that have settled.
Correct. Right. Now, I know there's also part of what comes into settlement is, how much money does this defendant have if I go to trial? So I was a plaintiff's attorney for 15 years, and it did not matter how much I could recover in a judgment. That amount of money was meaningless to me unless I was going to wallpaper my wall with pretty judgment numbers, right, with lots of zeros on it. The only number that mattered to me is how much money can I get from this particular defendant.
Right.
And in the brokerage space, the problem the plaintiffs have is they sued a bunch of people that don't have a lot of assets, right?
Yeah.
Brokerage is not a asset intensive, right? I don't need a factory. I don't need a lot of inventory. I don't need a lot of materials, right? My biggest asset as a broker has always been my people.
Yeah.
Right. and they can move anywhere else they want, anytime they want, right?
Yeah.
That's my biggest expense. That's my biggest asset.
Yeah.
And so, outside of maybe owning some real estate or something, there's just not a lot of cash laying around doing nothing, right? So plaintiffs need to be realistic on what are they going to actually get. And I think so some kind of structure also that recognizes if there has been any damage as a result. I'd say that as a giant if, right? Realize the money wasn't in the hands of NAR. Certainly the money wasn't in the hands of a multiple listing service or a
No.
local association, right? It probably is not in the hands of the broker, right?
No.
Who ended up with this alleged extra money?
Yeah.
It's by and far the individual agent.
Yeah. The agents have been the big winner in terms of how much of the commission, how it gets split up. The agents keep most of it.
Right.
The brokers, I mean, most brokerages are happy running, they're running on 4 to 7% profit margins, which is grocery store money. It's yeah.
Right. So recognizing that equity just says, right, fairness just dictates that how do you bring the individual agents into the fold, right? You could do something like a NAR assessment or some kind of assessment across all that. The problem is, I'm a part-time guy. I have a real job, right?
Yeah.
Should I pay the same as the highest level team here in my town where she's closing 145, 150 deals a year?
Yeah.
Right. In the span that I've done maybe 12.
Yeah.
Right. That doesn't seem
fair either. That's not fair either.
Yeah. Right. So doing it on some kind of, per transaction way, and it'd be easy enough to do to set up some kind of agreement that, hey, for the next 2 years, 3 years, 4 years, some kind of period of time, we take, $30, $40 from, a transaction side. Because remember at this point, no one's paid a buyer yet.
Right.
Right.
Yeah,
So there's still buyer claims sitting out there. So that's why I say transaction side would then create some kind of buyer pool. Right. That's where I see something like that, or some way of organizing around that concept being the most fair that we could get to.
Yeah, that's good. So we've got the rule changes plus a financial structure that works. I mean, we do have some questions that came in. One of them, I think you've answered somewhat, which is, how are brokers going to pay for this, this kind of a thing? And it's like, well, it will have to be a structured payment for most, if there is a settlement, it's going to be structured in some way over time, and tying it to a transaction makes a lot of sense because that's where the risk and the liability is created on the individual transactions. So we do have a few questions. I want to handle a couple of them that have come in, and then there's some that I think we can defer. I would be remiss to not note we'll have an Ask Me Anything on Friday on buyer brokerage compensation. If you'd like to attend that, just reply to the emails that are going out about that. Sign up for that. That's T360 has been doing those every month since October, since the Sitzer case ruling, and we're happy to take questions in advance. And some of these, we have so many questions, we're going to have to take some on Friday. One of the questions that has come in is about whether or not prices of houses are inflated because of the way that's one of the claims, like, oh, it's causing houses to be more expensive. I have a view on it. I'm just curious as to if you have a view on it, how you think that impacts the case.
I do have a view on it. I'd love to hear yours too. Mine comes from doing deals as a buyer's agent who signs a buyer rep agreement before we start the relationship. And I have done 4 for sale by owner deals, including the house I live in right now.
Yeah.
And when I talked with the seller of the house you're seeing the inside of behind me, I asked, how'd you come up with the sales price? You know what he said? I went on one of the online things. I figured out the house next door to me, which is almost the exact same size, sold 6 months ago for this price. I backed out what I assumed was the broker commissions, and that's the list price. And I said, I completely agree with you. I will pay that price. So it was literally a topic of the conversation of what the value of the property was in comps and adjusting out brokerage fees. I've also done transactions for buyers where I've gone to a seller that want a for sale by owner. I said, my buyer is paying my fee. I had people moving from California to another state. They had cash. I had the fee. They were going to pay me cash. And in the transaction, the buyer said, hey, can we maybe finance some of your commission in the deal? I said, sure. I went to the seller, said, let's take the price from 500 to 510 to cover some fees. That way it gets put in the loan. Seller said, no problem. I'm not paying any of the fees anyway. The buyer pays all the fees. So sure, whatever list price you want. And I've also done that in multiple commercial transactions where the seller said, no, I'm not paying the fee you asked for, Ed. No problem. We're going to increase the price by the exact amount of my fee. And that's what we closed at, right? So I think there's no question that the buyer side of the fees is part of the price that gets paid, because none of that money ever ends up in the seller's pocket.
Right. Yeah. Yeah. And we think similarly. I think there is in the current regime, the ability for the buyer's cost to be financed in is a greater ability to pay, increasing the price. Right. But conversely, if you say the buyer has to now pay out of pocket, can't be financed into the transaction, is paid separately, you actually reduce their ability to pay. And now they're kind of tied together, and it's sort of, you're going to pay for if there's a services involved, they're going to be paid for one way or the other. If they're financed into the transaction and they're just part of it, then the buyer has a little bit more of the ability to pay than if they have to write out of pocket, especially when you get in your average home buyer and your entry level buyers. So I think there's so sure, does it affect home prices? Probably. But it also makes it affordable for people to be able to even do the transaction. Whereas if they're having to pay by the hour or pay an attorney to do the transaction for them, they might not be able to afford it. It might not work out for them. So,
I think that's fair, that it may not be either extreme, but some kind of blend of the middle, right? Not every dollar is paid, by the buyer, but it's certainly not every dollar is paid by the seller either. So correct. I think that's a fair,
And then I think the other question is that I'll answer, and then there's many on these calls, which, by the way, we're going to run out of time. So I'm going to take the rest of these questions. Come to the AMA on Friday if you still have them. I'll attempt to answer any of them post, and so we can give you some good summaries on these. And there's some great questions that have been asked. There's one of our members here asked, talk about Fortune magazine saying that there's a $30 billion in consumer savings. Do you want to stick a pin in that balloon, or should I?
Yeah. There's a lot of eye rolling and laughing at some of these analysts who don't know about anything that we actually do in real life. Somehow suggesting that there's going to be this, more than 1 million less realtors and all of that type of stuff. Yeah. It's just fanciful thinking. Just be really practical, right? Those of you on this call do real estate. You understand how this works, right? Buyer representation with these little changes is going to be alive and well. I'm going to argue it'll actually probably be better, right? Great buyer agents will be able to charge more money, right? And there's just going to be a difference. People are going to make different amounts of money. That's not a bad thing. Buyer agency's not going anywhere. There's not an extra 3 or 4% in the deal like some of these consumer advocates and plaintiffs are saying. That's crazy talk. If they did any actual analysis of like the Australia model or English model that they try to compare to, they'd realize that in the United States, all of the marketing fees are borne by the agent as part of this fee. In those other states, they're not. The seller has to cut a separate check, sometimes for $20,000 or $30,000. Woo. Right? Also, look at the average price of a home on Australia versus the United States. It's a very big difference, right? Yeah. So the difference of 1% in Australia is actually kind of double what it would be here, right? So once you make some of these adjustments, you realize that the US system is by far the best consumer experience and best bang for the buck and best value that exists. So I read some of these articles from these outsiders, and it's clear that they don't know what they're talking about.
Well, and I think this is not a consumer windfall. They want to present it as some concern, like there's all this money being charged that shouldn't be charged. There's services being delivered, and those services will continue to be delivered in some form or fashion in the future, because we've proven, and again, I think it was another question, on a tail of this, to say, look, we unbundle service, we do things different. the industry has tried that for decades. We have
Right.
tried limited service agreements. We have tried, there are fee for service brokers today. There's, MLS entry only brokers today.
Absolutely. We have that at CRMLS. Absolutely.
There's a plethora of options for different ways of engaging with real estate, and fee for service has been an option for decades.
Sure.
And what we found, and this is T360 as a research firm, I'm speaking to our research, what we found is the US consumer and the Canadian consumer prefers full service real estate. They prefer a full service. They don't like a la carte because they don't have the expertise to do it. They prefer to go to someone that they know, like, and trust, who's competent to handle them and will take them through a transaction and be paid at the end. They actually like that. They don't, when you go and you say, oh, we're going to make you pay by the hour, pay up front, things like that. Models that have tried to do that have not typically done well. They still exist. They don't not exist. They're just not the dominant model. And so people prefer that full service piece. So I think we're of similar minds on that's sort of very fanciful thinking by non-industry people that there's not $30 billion in fees being charged for no value. There's value there, and we can be confident in that as an industry.
Yeah. Those are the people who've never actually opened the door for somebody, walked through a home, and tried to do the marriage counseling / analysis of where your kids want to go to school, all the things that we do as buyer agents that are not about, this property is for sale. That's the least valuable thing we do, is tell people what properties are for sale. It's all the other things we do to bring a transaction to fruition and to make sure that this consumer, this buyer, is matched to the best home for them and their family and their situation.
Yeah.
Whether that's a financial situation or where they are in their stage of life. That's what we're great at. And that's what we bring to the table, not telling you 123 Main Street's for sale. No one needs to hire us for that.
Yeah, no, that's marketing. That's already done. So, well, Ed, I just want to say thank you for spending the time with us today. Your knowledge is invaluable. Your perspective on these cases is tremendous. We do have, like I said, a ton of questions that have come in. We're going to do this again without Ed. It'll be myself and the brokerage consulting team on Friday at the same time. So come back. We're going to compile these questions and attempt to answer as many of them as we can, or all of them if we can. So do sign up for that. It'll be 10 a.m. Pacific on this Friday, and do join us. And then the last piece I'll say is if you are, as a broker, struggling a little bit with this issue or some of the changes, we have a standard assessment we're doing now to look at your buyer side of the business and how it's communicated and what changes may be coming, and to help come up with a plan and communicate that plan to your agents, because most brokerages need to put some kind of plan in place to get that part of the business strong and ready for any rule changes or any impacts that may come. And do reach out to us. We've worked with about 35 brokerages right now that have gone through that process with us. So again, Ed, really thank you so much for spending the time. I know it was invaluable. I can always tell when the Q&A is noisy and the chat's noisy that we've hit a very hot topic. Lots of great questions, and we'll do some more follow-up on Friday. But thank you again. Tell Art I said thank you as well for lending some of your time to the industry via T360.
Thanks. I appreciate all the work you guys do, and thanks for the opportunity to share some thoughts today.
That's great. Thanks, everybody. We'll see you on Friday or on our next call. Have a great week, and go sell some houses.